car, my client's rental car, to drive back to the hotel where we were staying, and this black Lincoln Navigator pulls up right in front of us and stops. My client walks over to this Navigator. He talks to this guy for a couple of minutes, gets back in the rental car and says, we got to make a quick stop before we go back to the hotel, and which leads us on this kind of maze-like route through the warehousey, meatpacking bowels of Chicago to what looked like this Sopranos-esque oasis in the middle of this field of trucking depots and meatpacking plants. There was this bar, and that was red, like three-story red brick building tavern. Out in front of this tavern was a gentleman who looked like he just walked off the set of The Sopranos. He was like 450 pounds, wearing dark sunglasses and a crushed velour tracksuit, parking the only cars that were there, which was ours. And he took the keys, parked the cars, and we walked inside, and we looked like we just walked onto the set of either the Sopranos or The Godfather. And it became pretty apparent to me, without knowing anything about any of the people we were meeting, that the people we were sitting down to meet with were criminals. When you are running criminal background checks for people with whom you are going to do business, when you're talking to people, it almost certainly will not be that apparent. And you almost, for reasons we're going to talk about in a second, you don't want to make these stereotypes of some people might be predisposed to having crimes in their background and other people might not. You want to go through the process. You want to engage in these criminal background searches to make sure that you are getting accurate information and you can make a fully informed decision about the people that you are going the people that you're looking to onboard into your organization. Unfortunately, there's two huge roadblocks. We talked about one last time, that being the Fair Credit Reporting Act. And if you were not on the webinar last time, I suggest you go to BackTrack's website where it is archived, and you can watch the webinar in its entirety, where we talked about roadblock number one for these criminal background checks, which is the Fair Credit Reporting Act. Today we're going to talk about the second roadblock, which is the Equal Employment Opportunity Commission, the EEOC. And the EEOC has, particularly in the past 6 years, coinciding pretty closely with the inauguration of Barack Obama in January of 2009. The EEOC's stance more as a legislator as opposed to a regulator has really, the EEOC has really enhanced their position more as a legislator than as a regulator. The EEOC is a regulatory body. They're supposed to enforce the laws that are out there. But what the EEOC has really done in a lot of areas, criminal background checks being one of them, is they have regulated, or they've legislated as opposed to regulating. They seem to be trying to create laws as opposed to interpreting laws that are out there. And so when we think about kind of what's on the EEOC's radar, you have to remember that the EEOC is a federal agency. It's confined by the dollars that are budgeted to it, our tax dollars that are budgeted to it, and therefore, while they would like to do everything they can to eliminate discrimination in the workplace, a laudable goal, the EEOC, confined by its budget, has to really get its most bang for its buck. So in order to do that, the EEOC has really targeted what is called systemic discrimination. You can go to, the link is here, to the EEOC's website to take a look at their strategic enforcement plan for fiscal years 2012 through 2016, and you will see all over that enforcement plan this idea of doing whatever it can to eliminate systemic discrimination. What is systemic discrimination? Systemic discrimination is discrimination not against an individual, but discrimination that works across a broad class of individuals through the enforcement of a policy. It could be a policy that intentionally discriminates, like we're not going to hire black people or we're going to fire all the pregnant women, or it could be more what we're going to be talking about today, which is a neutral policy that nevertheless tends to discriminate on the basis of some protected characteristic, whether it be race, sex, national origin, religion, what have you. One area where we've seen this come up locally, this issue of systemic discrimination, is a very high-profile case that the EEOC launched against Kaplan Higher Learning right here in federal court in Cleveland, Ohio. That case was dismissed by our local federal judge, Patricia Gaughan, and that was upheld by the Sixth Circuit down in Cincinnati. The case did not involve criminal background checks; it involved credit checks. Kaplan was requiring a credit check of all individuals that applied for employment, and the EEOC took the position that because certain minorities have disproportionately worse credit than Caucasians, as a matter of just raw numbers, that applying that policy had a tendency to discriminate against African Americans and Hispanics. The EEOC ultimately lost the case on the basis of their expert. They hired this guy who, in order to determine, in order to build the agency's statistical case, he engaged in a practice that he called race rating, where he would, because the EEOC or Kaplan didn't keep records of the races of individuals that applied and were rejected for employment. And so what this expert did was take the names of all these people, which Kaplan did have, pull up their records from the Bureau of Motor Vehicles, and then based on their driver's license photo, determine what their race was. And you can think for a second how offensive it is, at least to me, for an agency that is supposed to be charged with eliminating discrimination is using, look-based stereotypes to build their case against Kaplan for the use of credit checks. EEOC lost that case. They used the same expert with the same type of criteria in a case challenging criminal background checks, and the EEOC lost that case. That was down in Virginia. The EEOC lost that case also. Some other, we're going to be talking a lot about criminal background checks, but some fairly high-profile cases that the EEOC has litigated in this area. Just to mention them briefly, they filed a case in South Carolina against BMW. They filed a case in Illinois against Dollar General, and they actually had a case filed against them by the attorney generals of various states in Texas. The AGs lost that case, but we're going to be talking about the EEOC's enforcement guidance on arrested conviction records, which forms the basis for all these rules that the agency is trying to enforce. And the EEOC lost, or the AGs, the attorney generals, lost that case, where the court said the EEOC basically had the authority to issue these rules, to issue this enforcement guidance. But both the BMW case and the Dollar General case, which I looked yesterday, are still ongoing. Both involve this idea of systemic discrimination through the use of criminal background checks. What are we talking about here as a matter of, we kind of danced around the margins a little bit, but I want to kind of get into the details of what exactly it is we're talking about with this idea of how the use of criminal background checks discriminate. As I said, discrimination comes in two forms. We're going to be talking mostly about what's called disparate impact, but you could discriminate in the use of criminal background checks intentionally. That's called disparate treatment. It's intentional discrimination. It could be where you are only seeking criminal background checks on your minority applicants, where if you have a white person apply for a job, you are not asking you are not pulling a criminal history on them. But if you have a African American or Hispanic individual apply, then you are pulling a criminal history on them. It could be where you have two similarly situated applicants for a position, both with the same type of conviction history that comes back, and you hire the white applicant and not the black applicant. Another example of what would be intentional, what the EEOC and probably most courts would view as intentional discrimination, disparate treatment. That's not really what the EEOC is focusing on. The EEOC is focusing on this broad, systemic use of criminal histories in the hiring process. They are looking at, let's back up for a second by just briefly mentioning, what are we talking about when we talk about criminal histories? We're talking about anything that could tend to show whether or not someone has a conviction, or an arrest or conviction in their past. It could be a court record. It could be Department of Corrections records. It could be sexual registries or watch lists. It could be FBI or state law enforcement registries or repositories. A whole bunch of different databases that compile this information broadly under this umbrella of criminal histories. And a recent survey suggested that as many as 92% of employers subject some or all of their job candidates to criminal background checks. And there's good reasons why employers might want to do that. You want to know who you're hiring. You want to know, we all know that things like employee fraud and theft are big problems, big issues for employers. You want to know if someone has a conviction in their background that would maybe predispose someone for committing a fraud or theft offense in the workplace, concerns about workplace violence, concerns about potential liability for negligent hiring if you don't run a criminal background check and someone had a criminal history in their background that you did not know about, and you hired them, and let's say it's a crime of violence, and they assault a coworker or a customer or a vendor while under your employ while performing their work duties. Could you be responsible? Could you be liable for negligently hiring that individual, not doing everything you reasonably could, to discover what was in that person's background before you made your hiring decision. All good reasons you want to hire someone, and the EEOC is honing in on this because of the disproportionate impact of criminal convictions on certain minorities in this country. Again, when we talk about disparate impact, we're not talking about this targeted, honed-in, specific, intentional discrimination. We are instead talking about a broad-based, company-wide, facially neutral policy that, through its application, tends to impact a protected group more harshly than a non-protected group. And so what you're really looking at here to figure out whether or not a disparate impact exists, are the numbers, are the statistics. Let's take a look at the numbers in regards to criminal convictions so we can get a sense on why the EEOC views the use of conviction histories in employment as having a disparate impact. The EEOC and the numbers really do bear out that if you just use conviction data, it will more likely than not impact minorities over non-minorities. Let's go through some of the numbers. The numbers go back to the last census, or 2010 is the most updated data we have. But as of the last census data, 28% of all arrests made in this country are of African Americans, even though they comprise only 14% of the general population. Hispanics are arrested on federal drug charges at a rate of approximately 3 times their proportion to the general population. And then if you look at the incarceration rates, the numbers are almost identical. 1 out of every 17 Caucasian men, or 5.9% of the Caucasian men in the United States, should expect to be incarcerated at some point in their life. 1 out of every 17. But if you look to Hispanics and African Americans, the expected rate of incarceration climbs dramatically. For Hispanics, it's 1 in every 6 Hispanic men, or a little over 17%. And for African American men, it's almost 1 in every 3, or a hair over 32% of African American men will be incarcerated at some point. In their lives. The incarceration, if you compare African American men to Caucasian men, African American men are incarcerated 7 times more than Caucasian men, and for Hispanics it's a 3-to-1 incarceration rate when compared to Caucasians. When you throw all these numbers into the kind of blender, the EEOC takes the position that the use of criminal conviction, because how much more dramatically convictions impact African Americans and Hispanics as opposed to whites, the EEOC takes the position that the use of criminal convictions do in fact have a disparate impact. This is what the EEOC is going to look at to determine whether or not there is a prima facie or a presumptive case of disparate impact. What is the challenged employment action? Here, the use of criminal conviction histories. And then B, does it have an adverse impact on the protected group via a relevant statistical analysis? And I don't care how you throw these statistics into the disparate impact blender. When you were looking at rates of 7-to-1 or 3-to-1, you're looking at rates of several standard deviations. So no matter how you slice it, it's pretty clear that the use of criminal convictions have a disparate impact based on race or national origin, which makes them presumptively illegal under Title VII. But it's just presumptively illegal because we're not talking about intentional discrimination, and so employers have the ability to disprove this disparate impact, and they can do this in a couple of ways. They can, number one, challenge these statistics. Again, remember that the EEOC is basing its presumptive determination of disparate impact on national statistics. So you can go to the EEOC if you are have a discrimination charge filed against you, or if, God forbid, you're being litigated against by the agency in federal court. You can say, those statistics aren't us. It's not our, an employer, in East Cleveland is going to have a much different racial composition of its workforce than an employer in, East Lincoln, Nebraska, or somewhere in Montana or South Dakota where it's predominantly Caucasian. You can look at what your hiring, what the composition of your hiring pool is. You can look at what the composition of the crimes are. And so, drug offenses from a disparate impact standpoint are going to look much different, for example, than drunk driving offenses, which are predominantly Caucasian. If you look at the numbers, Caucasians are disproportionately arrested and convicted for drunk driving as opposed to minorities. And so you can look at the particular offense at issue and say there is no impact here because this offense that we're looking at doesn't disproportionately affect minorities. So you can beat up the EEOC on the statistics if your hiring pool or if the offense in question warrants, but as a general basis, you need to presume, because the EEOC will presume, that your use of criminal conviction in and of itself is going to have a disparate impact. Okay, so let's say we know we have the impact. We are statistically saying the policy does impact minorities more than non-minorities. That still is not the end of the story because employers have a defense available to them, and that is to show that the challenged employment practice, which is in this case again the use of criminal conviction histories, is both job-related and consistent with business necessity. What does that mean? All right, well, number one, it's the EEOC's, it's the plaintiffs, which in this case would be the EEOC's burden to prove impact, and we saw that presumptively the EEOC, at least with criminal convictions, takes the position that presumptively they don't have to do much to show that there is this disparate impact. And then the burden shifts. It's now the employer's duty, the employer's burden to prove job-related and consistent with business necessity. And the EEOC's position on what is job-related and consistent with business necessity depends on whether we're looking at arrest records or conviction records, because criminal convictions, criminal histories come in two flavors: arrest records and conviction records. talk for a second about arrest records, because generally, as a matter of course, arrest records are not great to use in making hiring decisions. Why is that? Because they don't presumptively prove anything. All an arrest record means is that there was, enough facts to create probable cause that someone violated the law, but it does not have the same checks and balances, proof beyond a reasonable doubt, a jury trial that exists when someone actually gets convicted of that offense. An arrest, unlike a conviction, an arrest is not proof of criminal conduct. It might not even be the proof that criminal charges, because in many cases arrests don't result in criminal charges. Someone's arrested and then let go within 24 or 48 hours, or charges are later dismissed. And of course, we know we have this presumption in the United States that someone is innocent until proven guilty. So for all those reasons, the EEOC takes the position, and I agree with their position, that arrest records are not great data for an employer to use in making a hiring decision. That if you want to look at criminal history information, much better to rely on the conviction than the arrest, because the arrest doesn't really prove that the person did anything. While an employer cannot rely on the fact of the arrest to support a decision not to hire someone or to fire someone, an employer can nevertheless use the fact of the arrest as a basis to dig deeper and disqualify someone for employment based on the underlying facts that gave rise to the arrest. What does this look like? I mean, what are we talking about? Let's say you have a principal at an elementary school who, after working there for several years, has 10, 12, 15 preteen girls come forward and say that this particular principal did some inappropriate things, touched them inappropriately, said some inappropriate things, and what have you. Based on those statements, this principal is arrested, and the school district fires the principal. If the school district violated the law, if this principal is either African American or Latino, has their application of a policy of terminating someone who is accused of this type of conduct, does it have a disparate impact based on this person's race or national origin? And both me and the EEOC will tell you that the answer to that question is likely no. You're not, the employer in this case is not making the employment decision based on the fact of the arrest, but is rather making the employment decision based on the underlying facts, that you cannot have a school principal remain on the job who has a dozen preteen girls come forward and make these types of accusations. And so it's not the arrest that is kind of the triggering event for the termination, but rather the underlying facts that gave rise to the arrest. What about criminal records? Criminal records don't have the same issues that arrest records do from a usability standpoint, because in comparison to an arrest, a record of a conviction is usually going to serve as more than enough evidence that the individual engaged in the particular conduct of which he or she was accused, because of all the procedural safeguards that are in place: innocent until proven guilty, jury trials, what have you. If it's a guilty plea, all of the constitutional protections that are in place when someone pleads guilty to a crime. So, for all of those reasons, the use of a criminal conviction is going to stand on much firmer ground than the use of an arrest record. But the EEOC is still, even though we have all these procedural protections in place, because of the statistics we looked at before, the EEOC is still going to want the employer to prove job relatedness and business necessity, and the EEOC takes the position that employers cannot do that if employers maintain an across-the-board policy disqualifying someone with a criminal conviction from employment. The EEOC says you have not met your burden to establish job relatedness and business necessity if you, as an employer, say, we will not hire anybody with any criminal conviction, period. Instead, the EEOC wants the employer, for each job applicant with each who shows a conviction history, to effectively link the specific criminal conduct of which the individual was convicted and the dangers that might kind of flow from that history of conduct with the risks inherent in the duties of a particular position. How does the EEOC want an employer to do that? The EEOC says that they'll take it one of two ways. They will either let you validate your use of criminal histories through specific statistical validation tools to create that, to show this job relatedness and business necessity. It's well beyond the field of the limited time we have this morning, but the EEOC has long published uniform guidelines on employee selection procedures that will walk an employer through how an employer goes about statistically validating the use of a test or a screening tool, and you can kind of put your use of convictions through these statistical matrices to show the agency the statistical link between a particular crime and a particular job, for example. That is an expensive proposition because you need to hire statisticians and number crunchers to kind of validate kind of each job versus each crime, and it is, especially depending on the size of your organization, that type of testing might become cost prohibitive. And so instead of that, the EEOC will instead allow you to develop what it calls a targeted screen. This targeted screen, the EEOC relies on what is now a 40-year-old case called Green versus Missouri Pacific Railroad, and says that this targeted screen must consist of three factors. You have to look at the nature and gravity of the offense or misconduct, how long it's been since the offense, misconduct, or the individual sentence ended, and then the nature of the job held or sought. And so what an employer is supposed to do to establish job relatedness and business necessity is apply these three factors: nature and gravity of the offense, time passed since the offense or conduct occurred or the individual sentence ended, and the type of job being held. You look at all three of those, compare and contrast them, and figure out whether, based on those three factors, you would still consider the applicant for employment. And it has to be done, on a job-by-job, position-by-position, applicant-by-applicant basis to figure out whether or not the individual is going to fall through this screen to continue on in the application process and be considered, or whether they're going to get caught in this screen and disqualified because the offense was too severe, it happened too short of amount of time ago as compared to how serious it was, and when you look at the combination of the seriousness of the offense and how long ago it was, because of the job you're hiring the person for, it would make sense not to consider that person any further in the process. And so, someone who, I'll give you an example. I represented a company defending a race discrimination lawsuit, and the individual who had sued, when I got his personnel file very early on in the case, and I looked at his job application, I noticed that he had a 25-year-old murder conviction. He spent 23 years in prison for first-degree murder. This company hired this person nonetheless. The job they were hiring him for was to don a hazmat suit and to go inside the tanks in wastewater, in water treatment plants, and scrub the the old sewage and stuff off the inside of his tanks when it was time to clean the tanks. And when I asked the HR director why they hired this person even though he was a convicted murderer, his answer was, who the hell else are we going to get to do this job? And it's a bit flip and it's a bit tongue-in-cheek, but if you kind of look at these Green versus Missouri Pacific Railroad, It was a very severe offense. He did kill somebody intentionally, but it was 25 years ago. He had been rehabilitated, and given the job that he was going to be working alone, and it was a job that was going to be very, very difficult to fill with someone that didn't have that type of background. And so the EEOC the employer hired this person anyway. So that's the kind of decision process that you as an employer have to go through when you are engaging in this targeted screen. The targeted screen, though, according to the EEOC, is just one step in the process, because once the person falls through makes their way through the screen, to continue on with the hiring process, the EEOC says that's not enough, because you still have to engage in what the agency calls an individualized assessment before you can let the individual know that they're not going to be hired for the job. And what does this individualized assessment mean? It means that even if you've decided you're going to continue on in the hiring process, may disqualify this person from hiring, regardless, you have to talk to the individual, have a conversation with the individual, let them know about the conviction, and talk through these facts that you know about the conviction and that you're considering disqualifying them from employment, and walk through these factors to see if the individual can convince you otherwise to hire them. A discussion about the facts and circumstances of the offense or the conviction. How many times was this person convicted of a crime? How long ago did the crimes occur? Has this person had a clean nose since they've been convicted? What was their work history before and after prison? What rehabilitation efforts have they shown? What do their job references look like? Is this person, bonded under some federal, state, or local bonding program that you can make a claim on the bond if this individual does something wrong? If the individual doesn't want to participate in this kind of interactive, individualized process, they don't want to talk to you about it, then you can disqualify them from employment for refusing to participate. But the EEOC says you have to make the effort to engage the individual, to make this individualized assessment, to figure out whether or not, based on all this information that you can gather from the individual, whether your policy of your application of this targeted screen as it would apply to this individual would or would not otherwise disqualify them from employment. It is a long, tortured, laborious process, and for a lot of jobs, it's really going to seem kind of silly and a bit redundant. I mean, if you are, if you own any business, for example, where you're going to send, people door to door, send individuals into customers' homes, that you're a pizza franchise where you're sending people, employees to people's homes to make deliveries, or you are some kind of home service provider, Merry Maids, or or a plumbing contractor, for example. We're going to be sending cleaning people or repair people into people's homes. You would never in a million years hire a convicted sex offender to go into a customer's home to do anything. It is way too risky. The liabilities, if that person recidivates and does something to a member of the public while under your employ, while on your payroll, the liabilities are astronomical for you, which is not worth the risk. And you can say a million times out of a million times, I'm not going to hire this person. But nevertheless, the EEOC is going to tell you that you have to put that person through the targeted screen, and before you let them know that they're disqualified from employment, engage in this individualized assessment, this back and forth interactive talking to the person to figure out whether or not you're going to hire that person or disqualify that person from employment. The other big hot button area that the EEOC is taking issue with is what's known as ban the box. ban the box is a very kind of catchy phrase that's been coined by some pro-employee lobby groups to try to have removed from employment applications the little box that asks whether or not you've ever been convicted of a crime. To date, 15 states, the District of Columbia, and literally hundreds of cities around the country have enacted ban the box legislation, making it illegal for some or all employers to ask on job applications whether or not an individual has been convicted of a crime. These groups will tell you that it is unfair for job applicants, unfair for people who are trying to get back on their feet, where they need jobs and need employment, need income, to be disqualified that early on in the hiring process, which is why they've pushed for these laws to make it illegal to ask these questions, and the EEOC is on board. The EEOC says it violates Title VII to ask job applicants on a job application whether or not they've ever been convicted of a crime. Ohio has not passed ban the box legislation. I know we have people on the line from all over the country. I'm sitting in Ohio. My state has not passed any such legislation. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 municipalities around Ohio have, including Akron, Cleveland, and Cincinnati. But that only applies for public employers. So in the city of Cleveland, you can't ask whether or not, the city of Cleveland's not asking whether or not someone's ever been convicted of a crime before they're interviewing people when someone's applying for a job. But if you're an employer a private employer in the city of Cleveland, that question, as far as I know, is still okay. Here's the issue I have with this ban the box legislation is you're doing nothing to change employers' mindset. If employers have the mindset that they are not going to hire convicted felons, they're not going to hire convicted felons. And so all you're doing is exponentially increasing the transaction costs for making a hiring decision, which might be great for our fine sponsor BackTrack, because if you want to find out what someone's criminal conviction history is under this ban the box legislation in a jurisdiction that has enacted ban the box, you have to pay for and run a criminal background check on every single person that applies for a job with your company. For employers, it increases the transaction costs in making hiring decisions exponentially. People who support this say we're putting that information just further on down the hiring process, so convicted felons have a way to kind of get further along in the process. That is true, but again, it exponentially increases the transaction costs for hiring, and it's not doing anything to change employers' minds. If an employer doesn't want to hire someone who is a convicted felon, the employer's not going to hire that person, whether they find out about it early on in the process or they find out about it just before they make their final decision when they run a criminal background check on the individual. Also, a lot of employers don't just ask this question because they want to know what a criminal, they want to know whether someone's been convicted of a crime, but they also use the box as a test on veracity. Is someone being honest with me? Are they going to honestly disclose what their conviction is? Or are they going to lie and try to bury it and hope I won't find out about it? The employment relationship being one that's all based on trust. If we don't, once that trust breaks down, the relationship is dead, really. And so if someone's going to lie to you out of the box, no pun intended, then that's someone that you're likely not going to want working for you. To me, if I was figuring out how to fix the problem, and it is a problem, how do we get convicted felons back to work? Because if they don't work, the odds of them recidivating, committing new crimes, and ending up back in prison is so much greater. I think you're better off putting your resources not in lobbying for these kind of ban-the-box laws, which I don't think does anything to advance the issue, but rather in putting resources in things like job training programs, certifications that people can get in prison, job training work certifications that they can then take to an employer to show that even though I've been convicted of something, I gained these skills and I was a good boy in prison, and therefore, I can demonstrate that you're not making a safety mistake by hiring me. But be that as it may, this movement, this ban the box movement, is really picking up steam. As I said, 15 states have enacted legislation prohibiting employers from asking these questions on job applications. Some of our largest private employers are now jumping on this bandwagon as well. Minnesota is one of the 15 states, and when Minnesota passed its ban the box legislation, one of its biggest employers, Target Corporation, said, well, we're headquartered in Minnesota. It's too difficult to have different hiring practices for different states, so we're just going to, as a corporate policy, just ban the box as a matter of corporate policy. And so Target no longer asks the question on its job application. Walmart as well, Home Depot, Bed Bath & Beyond, some of our large national retailers, multi-state organizations that are finding it too difficult as more and more of these states jump on board this bandwagon, make it more difficult to segregate hiring practices across state lines, figure it's easier just to have one uniform practice and just as a matter of corporate policy, ban the box. One question I get a lot when I make this presentation is, what about state and federal laws? Lots of industries are regulated, and lots of those regulations prohibit us from hiring certain people with certain convictions. The EEOC itself has gone 15 rounds in the various pieces of litigation it has filed challenging employers' use of criminal background checks in hiring. These employers have made discovery requests of the EEOC for the EEOC to turn over its own internal policy documents on its own internal practice of whether or not it hires convicted felons. And the EEOC has fought tooth and nail to prevent itself ever to turn over that information. And in all cases, the courts have said, you got to turn it over. And the reason why the EEOC has fought so hard is because the EEOC itself has a policy that says, if you have been convicted of a felony, we will not hire you, period. So the EEOC, the agency that is putting forth all these efforts to regulate the use of criminal histories in hiring, the EEOC itself has a policy against the hiring of convicted felons without using this targeted screen, without engaging in this individualized assessment. They just don't hire convicted felons. And the EEOC will tell you, well, we're a federal agency, and federal law is different than state law because federal law trumps state law, and we don't, but it doesn't trump federal law, and so we're allowed to kind of act differently, even though we think federal law says we should be doing things differently. We don't have to, but states you do. And so if you are, for example, an Ohio school district where Ohio has a law that says registered sex offenders can't be school teachers, can't work around kids, you cannot, as an Ohio state employer, you cannot apply that law without going through this targeted screen and the individualized assessment. So okay for the EEOC because the EEOC is part of the federal government, but not okay for things like hospitals, school districts, nursing homes that have very specific state laws about who can and can't work with what convictions, still have to engage in this targeted screen and individualized assessment, even though, as a matter of state law, your hands are absolutely and completely, totally tied. Which brings us to best practices to kind of tie this up with a nice, neat little bow. Want to make one point before I move on to best practices, which is, look, even though we've talked a lot about the EEOC's policies on the legal or illegal use of criminal background checks, I want to make sure we understand that there is nothing illegal about doing criminal background searches on job applicants. The Title VII, the federal discrimination laws don't tell you you cannot search, don't prohibit the searches of criminal backgrounds when making hiring decisions. It is an absolutely perfectly legal, justifiable, good best practice that you want to have in your business. the law that regulates how you engage in these practices, the kind of nuts and bolts of running these background searches, is the Fair Credit Reporting Act, which we talked about in our webinar back in January, which, again, you can go to BackTrack's website and to view that if you were not able to join us, if you were not able to join us last time. All the EEOC is doing is saying, if you're going to engage in the practice of running criminal background searches on job applicants, which is a perfectly legal practice, you just need to make sure you have the right policies and procedures in place to make sure that you are doing it in a way that doesn't disparately impact minorities because of the fact that they are minorities. And so what types of things should you be doing according to the EEOC to make sure that you are doing these background checks the right way? You want to make sure you have the policies and procedures in place so that the people making the hiring decisions, reviewing candidates, understand how to perform this targeted screen, understand the types of questions they want to ask in making this individualized assessment. You want to make sure you have specific matrices developed that will link specific jobs to specific offenses, so you know what offenses will disqualify which candidates from certain jobs. You want to make sure you have written job descriptions so that if asked, you can say, these are the essential functions of this job that we believe that this conviction acted as a disqualifying event. You want to keep records of all these people that are being hired that are either not successfully making it through your hiring process as a result of some criminal conviction. You want to have notes, records of how you applied this targeted screen, the individualized assessment you made of the particular individual. You want to make sure that your people that are involved in this process are receiving the right training so they understand the types of questions to ask, so that if you are challenged as to whether your decision was job-related and consistent with business necessity, you cannot just point to the individualized assessment you made, but you can show to the EEOC investigator the training you provided to the individual making that decision, so that the investigator has a level of confidence that your employee not only knew the right questions, asked the right questions, understood the questions to ask, understood the process, knew what to look for. I thank you all very much for our time together today. I left some time for questions if there are any. This is as I said before, it is a very, very tedious process for every job applicant to go through this targeted screen and individualized assessment, but it's a process that the EEOC is going to tell you if you want to make sure that your use of criminal conviction histories does not have a disparate impact. Is a process that you have to go through, have to understand. And so hopefully I did some today to help illuminate the process for you so you understand what the process is and how it's supposed to work. And with that, I'll open it up to questions if there are any. So thank you all very much.
Hey, thank you, John. We appreciate you once again doing this. Just a quick reminder that today's live webinar is eligible for the One General Recertification credit through HRCI. When the webinar is done, please complete the survey, and then we'll send the certificate to you afterwards. This presentation is being recorded. Will be on our website, too. So we had several questions about will it be there, it will be recorded. Yes, it will be. There are several questions dealing with individual states and their own ban-the-box laws. Where could you find a good resource to figure out what states ban the box, what cities ban the box? Can you point our people into some good directions for that?
Yeah, there is a great resource, if I can find my paper. NELP, which is the National Employment Law Project, they have published, it's like a 65-page state and local resource guide on ban the box, which walks through every state and local law and ordinance that has been passed on ban the box, and exactly what you have to do in each state or locality under each specific law or ordinance in order to comply.
Okay, thank
and
you.
I believe it's NELP. I believe it's NELP.org is the website. But what I can do is I can find the after we go off the webinar, I can find the URL and I can mail it to you, or if you can then disseminate it to all of our attendees.
Once this is recorded and on our website, we're going to send an email to everybody who registered, letting them know that it's available. So we'll include the NELP email or the NELP website in that too for everybody, so they have it. Next question. We have some clients asking about specific federal. For example, if you are in a financial institution, the FDIC does prohibit a person working in a bank who's been convicted of a crime of dishonesty, et cetera, and some of those crimes. Would it be acceptable to ask the question ahead of time still, or do you still want to wait and do it at the end or later on?
Yeah, because if you're dealing with a federal regulation like a federal law or regulator like the FDIC, the EEOC is going to say that everything we talked about today doesn't apply. That if there is a federal law or regulation that requires you to not hire someone based on a certain criminal conviction, a certain criminal history, then it's okay to do that. And so what I would do in that case, if you want to be proactive and ask the right questions, because you're worried about ban the box, you're worried that it might become law in your jurisdiction, or maybe it is law in your jurisdiction, or you're worried about the EEOC taking issue with your job application, it is okay to say, if you are applying for the following, positions, positions that will be regulated by the FDIC, for example, have you been convicted of the following offenses, and then list out the disqualifying offenses. That would be the safest way to do it. Or you can just, if you're in a jurisdiction in which ban the box has not been enacted, you can just ask the more broad-based question: Have you ever been convicted of a felony? With the understanding that the EEOC may come in and challenge that as a disparate impact. But there is nothing wrong if you are subject to a specific federal law or regulation from disqualifying someone right out of the box, right out of the chute, who's been convicted of a disqualifying crime without engaging in the targeted screen or the individualized assessment. If it's a state or local law, however, because state and local laws don't trump the EEOC, they don't trump federal law, the EEOC says that even though the rationale is exactly the same, there's a law that requires you not to hire someone, because it's a state or local law, the EEOC is still going to require you to jump through all these various hoops that we talked about today.
Okay. How does the process change if an offer has already been made for the position? So can you ask about the criminal records then? What do you recommend at that point in time once an offer is made?
I mean, you can certainly, there's nothing to stop you from, it really depends on when you wanted to run the background check. Some employers run them very early on in the process. Some wait until a conditional offer is made. There's nothing wrong with making a conditional job offer and saying it's contingent upon the, background screen, which may include a criminal background check, and then you run the background check and you see what comes back. But you're still, if a conviction pops, you're at that point, before revoking the conditional job offer, you're going to have to apply the targeted screen and engage in the individualized assessment to determine whether or not the conviction, you will still disqualify the applicant based on the conviction history.
Okay. Next question. I heard that most of the EEOC investigations come out of the southwest region of the U.S. because it's more profitable. Any truth to this?
I have never heard that. That I have never heard. I can tell you that one of the biggest ones that we've seen in recent history was the Kaplan lawsuit, which came right out of the Cleveland District Office. So there are investigations that go on in every district office, and I would not assume just because you are in Cleveland, Ohio, or wherever you might be, that it is that there is less of a chance that your practices will fall under scrutiny by the EEOC.
Okay. If your company has a policy to not hire anyone with a felony conviction, are we correct in understanding that you still have to have a targeted screening process for that?
Yes. The EEOC will tell you that policy without the targeted screen and the individualized assessment, that policy is going to be per se illegal, because the policy is going to have a disparate impact as it will be applied. And so if you you need to, in order to make the case for job relatedness and business necessity, you have to engage in the targeted screen and individualized assessment. Otherwise, you can't establish job relatedness and business necessity, and therefore the policy of not hiring convicted felons in and of itself is going to have an unlawful disparate impact.
Okay. What about if we're subcontracting for a company that has their own background screening requirements, such as an individual with a prior felony conviction can't be placed on the job? Do you still recommend the same thing, the targeted screen? How do you handle that?
Yeah, that would be a matter really of contract with the company as to who's going to perform. The targeted screen and the individualized assessment still has to be done. I think at that point it would be a matter of contract between the contractor and the subcontractor as who's going to run, who's going to take responsibility for that and who's going to indemnify whom in the event, litigation ensued as a result of background screening process being challenged.
Okay. If a candidate fails to disclose a criminal conviction on the application and it is found out in the background check, is it legal to withdraw the offer at the time based on the principle the application was falsified?
Absolutely it is, but this is where ban the box really comes into play, because the EEOC and 15 states and hundreds of localities take the position that you shouldn't even be asking on the application whether or not there is any criminal history. And so if you're not asking the question, if you can't ask the question, then you're not going to know. If you are asking the question because you're somewhere where ban the box has not yet been enacted and you are taking a risk that the EEOC is not going to challenge your application as illegal, you ask the question, you can absolutely disqualify someone from employment for dishonesty for lying on the application.
Okay. And last one, do you know of any federal laws that prohibit criminals from working as a financial or at a financial advisory firm?
Off the top of my head, I don't. You would want to look both to the Securities and Exchange Commission and or FINRA, FINRA being the regulatory body that regulates brokers and financial advisors. I am reasonably confident that rules like that probably exist, but off the top of my head, I couldn't point you in the direction of where they are.
Okay. All right. We want to thank everybody for joining us today. Just a reminder, fill out the survey at the end, and then we'll go ahead and send out your certificate afterwards. We want to thank you, everybody, for joining us, and stay tuned. We're going to have another one of these sometime in July. So once again, thank you, and have a great day, everyone. Bye-bye.